Yes, welcome to my live show on Facebook question and answer session. I'll give you answer. If you have any question, you can join with me to call the number appear on the screen. At the same time, I'll give you some important update today about the right to work of asylum seeker, whether asylum seeker can claim work permit from the home office while their asylum application is pending, and the whether the European citizen and their family member with pre-settled status can claim benefit after Brexit. Stay with me, and I'll come after a short break. Viewers, welcome back again. So let me start with European EU citizen and their family members. Brexit is knocking at the door. We don't have much time left. Only and 8 days left. Now, the first question is whether EU citizen or their family members still have chance or opportunity to come to the UK. If they come, whether it is possible for them to get pre-settled status or settle in the UK before Brexit. The answer is very straightforward. A lot of confusion, and people are confused about whether they can come. Yes, if you come before 31st December 2020, you can claim pre-settled status under EU settlement scheme. Although due to the COVID and the restriction on Dubai, most of the European country is disconnected, block the air and space and car, all the way they block. EU citizen cannot come. However, some countries still flight is coming. So if anyone comes before 31st December 2020, they can apply pre-settled status. A lot of people are confused that if I go to UK, what proof I can show. Some people are advising that if you don't have a national insurance number, you cannot claim pre-settled status. The information is not correct legally. Some people advising their relatives or people that if you come to the UK, you don't have any proof of address in the UK, you cannot claim pre-settled status. That is not correct. The legal requirement is if you can prove to the Home Office that you was in the UK at least for 1 day, you can claim pre-settled status. So how you can prove that you are in the UK at least 1 day before Brexit? You can show your air ticket or train ticket, Eurostar ticket. You can show your passport. If when you travel to the UK, you can ask the immigration officer to put a stamp on your passport. Normally, immigration officer, they don't put a stamp on EU passport because European passport. However, if you ask them, they will do it. So if you provide evidence that at least 1 day you was in the UK before 31st December, the Home Office legally required to give you pre-settled status. If they don't give you pre-settled status, you can go to court and ask them that the Home Secretary decision or the Home Office decision was wrong. So you can come before 31st December, although you cannot fly from some EU country, but rest of the European country, those who still accept flight from the UK, you can travel to the UK and make an application to the Home Office for pre-settled status. Same way, you can bring your family member as well. Now, it is not mandatory that you have to make the application before 31st December. If you come to the UK before 31st December 2020, that will be sufficient to establish your pre-settled status. You can make the application even after 31st December because the deadline for the pre-settled status application or settled status application is 31st June 2020. The deadline for free movement under the transitional period is 31st December 2020. So if you come before 31st December 2020, 11 p.m., you can claim pre-settled status. You can make the application even after Brexit. Even after Brexit, you can come to UK. So you can make the application after Brexit. In terms of pre-settled status, I'll give you the update that when you can apply or how long you can invite your family member to come to the UK. But before that, let me give some question, because this section is for live weekly question and answer session. If you have any question, either you can leave a comment below my video or you can call me. The number appear on the screen. First question, Jashim Khan. Assalamu alaikum wa alaikum assalam. It's a lovely prayer for me. First question. Next question. Chaima Ba, can you help me to write an invitation letter for my parents-in-law? I cannot help you to write a invitation letter on the live show, but if you need any help, you can contact to my office and my secretary will arrange some help for you to invite your parents-in-law. You are a lovely lady. You want to invite your parents-in-law. That's a great things. It's very good. You love your husband and you love his family. You want to bring your parents-in-law. Yes, we will help. Contact to my office, and someone will able to provide you some assistance. Afolo Labiko, you asked me. Hello, sir. I supposed to, but in UK by 31st December, but the lockdown cannot make me come till January. Please, what can I do? I don't know your personal situation on what basis you want to come to the UK, but it looks like you want to come under EU settlement scheme, because probably you are EU nationals, as you said, that 31st December, I presume like that. In that case, if you are a EU nationals and if you don't come 31st December 2020, you will not able to exercise rights under EU settlement scheme. However, if you are a EU family member, in that case, you can come after 31st December. If your visa expire, your family permit expire, you can ask the Home Office to give you a replacement visa. They are issuing replacement visa free of charge. Next question. Under settlement scheme, but they will come after 31st January. Yeah, that's no problem. You can invite your family member to come to the UK even after 31st January. There is no issue. So can't do residence card. Yes, I will call you. Thank you. Yeah, call. Then someone will able to help you, because we need to know about how you support them, whether they're dependent on you or not. So a lot of questions you need to give us answer. Then someone will able to help you. Thank you, Chaima Ava, for your call. You are I appreciate the way you are want to support your mother-in-law to come to the UK. So I was giving an update about pre-settled status. Let me speak about the asylum, and this is the one, the other part of my update today, because recently, last week, High Court gave a decision about right to work for asylum seeker. Asylum right to work policy, basically the High Court declared unlawful. The reason is there is a case, which is the case is RIJ Kosovo versus Secretary of State, Home Department 2020, EWH 33487 Administrative Code. So in this case, Home Office basically, the Home Office policy on permission to work for asylum seeker is unlawful to the extent that it doesn't allow allowances for potential victim of human trafficking. The High Court held that the policy will now have to be reworked to make clear that there is a discretion to allow asylum seekers to work in non-shortage of jobs. Now, a discretion that people in the trafficking system should be able to rely on in future. The reason is asylum seeker only get right to work if their decision is pending at about 2 years, then they can apply for right to work, and the Home Office only issue work permits condition that the asylum seeker will work only shortage occupation list. Now, what are the shortage occupation list? In the Home Office Immigration Rules K, Appendix K, there is a shortage occupation list, which is basically a very high level 6 job, above level 6 job, very high qualified doctor, nurses, engineer, scientists. So these types of qualified job. Let me tell me one thing: how many asylum seeker? You will not find 1 in 1,000 to be a scientist, to work in shortage occupation list. So majority asylum seeker fail to work on shortage occupation list despite right to work. So that's why that's the right to work of asylum seeker, they kept in the asylum system as a symbol. It's not a genuine, because most of the asylum seeker not able to work in shortage occupation list because this is skill. So the policy, immigration rules or immigration policy for right to work or to work permit for the asylum seeker, High Court declare unlawful. Now the issue is, I'm not sure how far the Home Secretary will act on the decision, because the decision is not obviously binding to the Home Secretary, because this is if the law is made by the Parliament, then Parliament is sovereign. Whatever said Parliament, this is the sovereign. Now the court decision, obviously it will impact the Home Secretary morally, should consider the decision of the court. So most probably the Home Secretary may review the asylum policy, and they will show some sympathy for asylum seekers, so that can claim work permit, and that work permit, their work right to work shouldn't limited to the shortage occupation list. The right to work should allow to work any sort of work as they want. And other thing is the discretion power to allow the asylum seeker to work should be allow enough discretion, because the discretion power is limited. So that's what it's all about is. But I hope next year the Home Secretary will reintroduce the asylum policy for right to work for asylum seeker, because right now it's not actually helping the asylum seeker. So back to my question again. General Rajik, I just want to information about student visa in UK. Yes, the general student visa, brother. If you ask me a specific question, I will be able to give you an answer. Yes, the student visa which reform, and from now on the new post-study work permit introduced, as well as some flexibility which is introduced. But the way people are saying that door is open, student visa open, this is not correct. Student visa always been open, work permit was open. This was reform, and some changes come. So if you have any specific question, you can ask me. You can leave a comment, or you can call the number appeared on the screen, and I will be able to give your answer. Let me take a break, and I will back again. So, Mr. Arsalam Mahbub, you asked me If wife has passed and she did apply for husband EU settle status, how long they do take? We have 4 month kid as well as I'm in UK as well. Has no status. Reply me, please. Thanks. Mr. Arsalam Mahbub. Uh, your question give me a feel that you are in a difficult situation, means you don't have any status, and I'm not sure whether you are married or not, because whether under EU settlement scheme or under EU law, you can apply as a family member. You can apply for a residence card as a family member. Family member means you partner or a civil partner, or a husband and wife, children under 20, over 20 dependent, parents. They are the, oh, you are married, brilliant then, okay. So uh, so in that case you can make the application. So if your wife gets settled status, you can apply and you will get decision within 2 weeks. 1 to 2 weeks you will get your decision. So that's brilliant. There is no problem, no issue. You can make the application and you will get your settled status 2 weeks. I'll advise you one thing, that make the application before 31st December, because your everything is ready. I don't know why you don't make any application yet. No problem, you don't have any status, just make the application and provide evidence. Once you make the application, then you are on track. And although you don't have status, but you have a child as well, so under Jim Brown and also you have right of residence. You are a EU family member. Once you are a spouse, you are a EU family member. It doesn't matter whether you have status or not. Okay, you can claim residence right to residence in the UK because you are a family member. Married, family member. There is no way you cannot claim a right to residence in the UK under EU settlement scheme as well as under EU law. But I'll tell you, don't wait, make the application. Yes, sometime it take more than 2 weeks when there is a issues. For example, you don't have any status, you are not on the system, then your application will be decided by a senior caseworker. Okay, that's why it take time, because normally when everything is straightforward, the caseworker will check everything in their system, they will give the decision. When there is everything is not straightforward, then they left the application to decide for the senior caseworker, and that it take time. You are waiting for 1 month. I presume you need to wait a more longer time, not even 2-3 months, couple of months maybe. So you need patience, brother. Wait, inshallah, you will get your decision soon. If you want to know more about the update, you can call the EU Regulation Center, and the caseworker will check and they will let you know. Also, you can check online and check whether anything the caseworker asked for you. Because if you log on there, if they ask any further evidence or if they send any question or any request, you will see on the system. Inshallah, good luck, brother, for your EU settlement settled status. Do you know if Home Office are still working? Tahmida. Yes, Home Office is still working, but most of the caseworkers are working from home. But the process is not slow most of the case. If the things is straightforward, the process is going well. So there is no issue about it. Let's go ahead about the EU settle status again. Now, as I said on my first video, that a case which is very important case for the EU citizen, majority EU citizen, those who basically came in the UK and apply for pre-settled status, the question is whether they can claim benefit after Brexit, because right now until transitional period, they can exercise, they can argue, or they are claiming benefit under the European law. There will be no discrimination on basis of their nationality. That is what all about European law is. But after 31st December 2020, there will be no European law. So that time, EU citizens' right and their family member right will be dealt by the EU settlement scheme, withdrawal agreement. Now, under the scheme, many people are getting a pre-settled status. The pre-settled status is a limited leave to remain because they issue pre-settled status 5 years. So the question is, under the pre-settled status, will the EU citizen able to claim state benefit, housing, or universal credit, or tax credit, child benefit, because this is a public fund. Generally, uh, under the national immigration law, EU citizen, any citizen, whether EU or non-EU, cannot claim benefit when they have limited leave to remain. So this was a confusion, and Home Office approach was that they will not give access to public fund after Brexit those who has pre-settled status, whether you are a settled, whether EU nationals or non-EU nationals. However, there was a very important case and leading case decided by the Court of Appeal, and they cleared the position and confusion that whether the EU citizen and their family member can claim benefit after 31st December 2020. The Court of Appeal has handed down a ruling that should, if not successfully appealed, and make it easier for millions of EU citizens with pre-settled status to claim benefit. The case is Fratilla and Tanasa versus Secretary of State for Work and Pension 2020. And in this case, the court ruling clearly cleared the confusion that whether the pre-settled status holder can claim a benefit or not. And it said, yes, EU citizen with pre-settled status can continue to claim state benefit. So if you have any question about it, I hope this will clear your confusion. Because this is these two important case what we have right now, but I have received a question. Before that, I will go to a small break, and after come back. So the question asked me by Henrietta Gansha. You ask me, I'm a EU spouse, refuses to support the wife for her indefinite leave to remain. What will qualify for it on her own? I'm a EU spouse, refuses to support the wife for her indefinite leave to remain. That what will qualify her for it or on her own? Your question is not clear to me, but most probably I presume that you said that your EU spouse or either you are stopped supporting or he was stopped supporting. But anyway, if an EU national's relationship breakdown with non-EU national or non-EU nationals who has residence permit or permanent resident permit on the basis of your relationship with EU nationals, and you cannot make the question is now your relationship breakdown. Now the question is whether you can continue to keep your right of residence. Yes, certain circumstance, despite the EU nationals without support, the non-EU nationals can retain right of residence. There are a couple of circumstances under Regulation 10, and the same as in EU settlement scheme, the non-EU nationals can can retain right of residence under the EU settlement scheme. EU law is very realistic. In a British English law, a British law where the relationship with a spouse, if breakdown, the day is breakdown from next day, the visa of a non-EU spouse, non-British spouse, curtailed by operation of law. He will not able to extend by himself unless he or she have any child, British child. So English law doesn't give any protection to a non-British spouse. However, in European law, give a protection to a non-EU spouse if, in case their relationship breakdown uh, with EU nationals, and that is an alternative route which is called retained right of residence. So, if non-EU spouse can establish that his relationship with EU spouse lasts for 3 years, then he can retain right of residence. His marriage is not dissolved by decree absolute, he can retain right of residence. If he is a carer of a EU child, he can retain right of residence under the Zambrano case law. If he have retained right, he can retain right of residence. If he have a European child and he have access to this child, he can retain a residence. If he can establish that his relationship broke down because of domestic violence, he or she can retain right of residence. If his or her spouse passed away, he can retain right of residence. So these are the couple of circumstances where non-EU spouse can retain his EU residence card despite or without support from non-EU spouses. I hope this question is relevant for many applicants, and it will helpful for you if you need any help or if you don't want to. Hi, Anata Ganush. I hope you understand your legal position. It might not become to in your favor, but this is the answer and this is the law. So I was giving information about European law, and then I gave some information about the asylum seeker, whether the asylum seeker should get their right to work while they're in the UK. Now, in my last session, I also spoke about the changes came on asylum law, asylum policy, the admissibility rule and inadmissibility rule. If you have time, you can watch my last week program, and then you will find a few answer and update about asylum. Then I will also give you some information about the European law again, about parents. If any EU citizen want to bring their parents, or if a non-EU family member want to bring their parents, whether they can bring them even after Brexit, or what document they need, should they need to provide evidence that their parents is dependent on you. Because Regulation 7 said dependent parents, same as EU settlement scheme, the wording is dependent parents. But actually, does the law require that they are dependent? Do they need evidence? I'll give you specifically the answer, because thousands of parents' application for leave to enter under EU law as a EU family member refused by the Home Office on unlawfully, unreasonably they refused because the case of said that I'm not satisfied that you are a dependent on your EU family member or non-EU family member. This is unreasonable because law doesn't require the evidence of dependency. I'll give you a reference after give some answer. So, Katini Narda, very nice name. Unfortunately, I cannot pronounce, but I'll tell your first name. Forgive me if I'm wrong on pronunciation. Katini, will the rules be changing for applying for naturalization for a 10 years old? I hope no. I hope no. Kenya's rules, I hope, I wish it will not be changed. But who knows this government? The Boris Johnson Prime Minister, how many times he changed his policy about COVID? Eh? How many times he changed the lockdown? So we don't know about the government approach. But Home Secretary, the immigration rule is more uncertain than the number 10 because immigration rules every month, every year, couple of times they change. But I hope 10 years rules will not be changed. This is my expectation, like many parents who has a hope about 10 years old. But Katani, I hope your child is going to be turned 10 and will be a British citizen, and you are hoping that you will apply on the basis of your family life with your child. But I hope you know about 7 years rule. Once your child turns 7 years, you can apply. If you don't have any paper, if the child hasn't any status, you can apply for your child to get leave to remain on the basis of human rights, 7 years rules, private and family life. And you can get his first visa. The government, you can go to even 1 day premium service if you provide the birth certificate of him, then he will get visa. What you need to prove that your child was in the UK, and he spent at least 7 years, continuous 7 years before he turned 18. If he born if the child born anywhere outside the UK, if you can prove that the child spent 7 years in the UK, then he or she can claim uh, uh, leave to remain on the basis of private and family life, Article 8. And normally, most of the cases, Home Office issue visa. Now, once your child get leave to remain, then you can claim leave to remain on the basis of your private and family life with the child. This is also a route what you can think about it, and rather than wait for 10 years to make an application, if you cannot pay the Home Office fee, because when you apply for your child, the Home Office fee will become around £2,500, including the NHS fee as well as the Home Office fee. But I'll advise you, if you cannot pay the Home Office fee, you can make a fee waiver application to the Home Office. Right now, a lot of fee waiver application accepted by the Home Office. If you don't have enough earnings, you can make an application fee waiver and NHS fee exemption application, and Home Office will accept. I hopefully considering your situation, and you can make the application free of charge. If any child also under 25, he or she spent half of his life in the UK, also he or she can claim a right to remain, limited leave to remain on the basis of their private and family life under Article 8. So there are a couple of circumstances where someone can claim family life in the UK. I also give an update. Right now is restriction 4 most of the part of the UK. So it is very difficult for migrants to live without public funds because most of the people cannot work or they cannot earn enough money to maintain themselves. So in that situation, the Home Office are helping to those people who need help. If you don't have access to public funds, or if your BRP say no recourse to public fund, then that means you cannot claim universal credit or you cannot claim child benefit. In that circumstance, if your circumstance is changed, if you face difficulty to pay the Home Office fee or to pay your rent to buy food for your family, you can make an application to the Home Office to give you access to a public fund. That is, they will change the condition of your BRP from no recourse to public fund. They will remove it, and then you can claim benefit, public funds, child benefit, universal credit, or housing benefit, housing accommodation from local authority. Right now, the Home Office very show their sympathy and they are realistic. They are giving access to public fund. A lot of application I made for few waiver application as well as access to public fund. Most, I mean, 100% my application were successful. Every applicant now get access to public funds. So if you are in difficult situation, make an application for recourse to public fund, and once they remove the no recourse to public fund from your BRP, you can claim all short of public funds. Accordingly, fee waiver, if you need any help, if you cannot pay the home office fee, NHS fee, you can make an application to the home office to give you waiver from NHS fee or exemption. This will not impact negatively in your application, because some people confuse that if I make an application for fee waiver, the home office will think that I'm a burden of this country, then they will not receive visa. This is not the case. You have right. This is the law. This is the policy made by the parliament to help people. You can make the application. It will not impact the decision maker to give you a leave to remain in the UK or not. So if you need any help about public funds or about fee waiver or NHS fee exemption, you can contact to the Home Office and they will provide. You need to make an application, but fee waiver application and to change the recourse to public fund, this application are very technical. I would say you should consult with a solicitor or advisor about the legal requirement of this application. So this is for today. I hope this information will help you, help our community, all of you. Enjoy your time, and if you think today information will help our community, our migrant brother and sister, please feel free to share this video. This is very difficult time. All of we are passing. A lot of people fail to celebrate their Christmas. A lot of people business affected. A lot of migrant passing very difficult time. A lot of people stuck in the airport. A lot of people stuck at home. They cannot travel to Europe. A lot of European people want to come to the UK. They cannot come to the UK. So this is the situation where we are. If you cannot travel from UK, from Europe right now, but which will lead, that means you cannot come before 31st December 2020, you can make an application for pre-settled status for leave to enter. This is the one, another way you can come after Brexit, if the Home Office issue pre-settled status, because pre-settled status you can make from outside the UK as well. So good night, everyone, and all of you, if you think this information, please feel free to share my video on your timeline. Thank you.